organizations. So the the laundering of criminal funds aims at giving a legal appearance to dirty money, whereas the laundering of terrorism funds aims at excursing the assets of a legal origin. Next, please. So under this slide, we have covered the country-wise ranking of the money laundering as per the Basal Index. The Basal Index is an independent annual ranking that assesses the risk of the money laundering and terrorist financing around the world. The Basal Index is a research-based index by a non-profit organization ranking countries according to their risk of money laundering, terrorist financing. The risk scores are being based on the data derived from the publicly available sources such as FATF, Transparency International, and the World Bank. When you see the colors of the region becoming lighter to darker, it symbolizes that the region's deficiency and ineffectiveness in quality of AML and CFT framework. The main objective is not to rank the countries in comparison of each other, but to provide an overall picture of different countries and region risk levels and the progresses in addressing vulnerability over the time. So the countries with high risk is required to take corrective measures to change the behavior and debtor to non-compliance. Next. In this key regional focus, we have highlighted the Middle East and North African region. So the UAE ranks 37th on the list with a scoring of 5.89, indicating the high level of the financial secrecy and AML risk. The risk levels in the MENA region are higher than the global average. In this regard, the governments are urged by the FATF to increase performance in public transparency and AML CFT framework. However, with the introduction of the AML law, it is evident that the UAE has tried to match its investigative powers and channels to collect the and use of financial intelligence and curb the activities relating to the money laundering and financing of terrorism. More powers has been granted to the public prosecutions. Also, there is a growing concentration on the development of the new technological tools that can enhance the ability of the law enforcement agencies not to collect the financial intelligence, but also to identify the patterns in criminal activities and prevent the abuse of the financial systems that has been prevailing in case of the money laundering activities. Next, please. Now, under this slide, we have covered the importance of the ultimate beneficial ownership in context of the AML and CFT regulations. So recently, there had been an enactment of UBO regulation, that is Cabinet Decision number 58 of 2020, which require all the businesses and entities registered in the UAE to disclose their real beneficial owners to the licensing authorities. The UBO pertains to the legal entity or individual which actually owns a company by means of chain of ownerships, or there are some provisions being given in the regulation by which we can derive to the real owners of the company. The main purpose is to ensure that companies are not unwittingly entering into any transactions where the ultimate owners are being involved in financial crime activities. Next, please. So we have covered here in the applicability of AML regulation on the UAE businesses. So you can see there are mainly two categories under which the AML regulation currently applies. So first is the financial institutions. Mainly the financial institutions covers those institutions which are dealing into financial and credit terms. So it covers the banks, it covers the exchange houses, etc. Then second number comes the DNFPBs, which is the designated non-financial businesses and professions. So under this, there are main four categories of the professions being covered currently. To start with, it is a real estate brokers and agents, those who are mainly engaged into buying, selling, and leasing of the real estate properties in the UAE. The next one is the notary public and accountants. Then comes the dealers of the precious metals like any gold, diamond, and jewelry businesses. Then comes the corporate service provider. So corporate service providers are those mainly who are helping the companies in setting up their businesses in the UAE, in opening the bank accounts in the UAE. So all these categories are being currently covered under the AML regulation. Next, please. So under this, we have highlighted the registration requirement, that what are the registration requirements for DNFBBs currently. So for financial institutions, mainly all are being registered with the central bank, because this regulation came into force 2-3 years back. So that time all the financial institutions were being registered. Also, there was an mandate requirement for DNFBBs to be registered, but now there has been a deadline being given by the authority that by 31st March 2021, all the DNFBBs are required to be registered under these two systems, namely goAML portal as well as Committee for Commodities Subject to Import and Export Control System, that is the automatically reporting system for sanctions. When we are doing the registration, there is a mandatory requirement to appoint the money laundering reporting officer. So the more details of the money laundering by my colleague Isha coming session. Next, please. So on this note, I would like to hand over to Lydia to take the session further and introduce my colleague Isha D'Souza. Thank you.
Thank you so much, Sakina. Yeah, now I would like to welcome Mrs. Isha D'Souza, who is Director at Risk Advisory at MBG Corporate Services. Isha has more than 15 years of international experience across internal audit, external audit, internal controls, risk management, AML and fraud management, and investigation in India, Singapore, Qatar, and UAE. She's a qualified chartered accountant. Her experience includes external audit, internal audit, compliance audit, and other engagements in various industries, including banks, financial institutions, real estate companies, hotels, malls, educational institutions, charitable institutions, and healthcare organizations. Isha has a wide experience in investigation and forensic audit for charitable institutions and NGOs. Isha has been involved in the corporate governance reviews for leading corporates and has led various policies and procedure engagements, internal audit, and has been involved in conducting risk assessments and development of risk-based internal audit plan for several clients. She will talk today further on the AML and CFT compliances for Middle East-based companies. Isha, please take it forward from here.
Yes. Thank you, Lydia and Sakina, and a very good morning, everyone. Next slide, please. I would be discussing on how organizations can comply with the regulations. To comply with the AML CFT regulation, every organization must have a compliance framework. To create the framework, there are certain key focus areas and key components that go hand in hand for creating a robust compliance framework. The key focus areas for the framework are adequate compliance culture and framework within the organization, including the MLRO roles and responsibilities, adequate resources, skill, knowledge, and experience with the organization to develop the framework, implementation of effective systems and controls to combat with the AML CFT risks within the organization, and periodic monitoring and reporting to the supervisory authority or financial intelligence unit of any suspicious transactions. Accurate record keeping to comply with the regulatory requirements, periodic and effective training and awareness across the organization, review and update of changes in accordance with the changes in the regulation. So these are the key focus areas. Now, I would like to talk about the 5 key components of the compliance framework. Based on the Federal Decree Law number 20 of 2018 and the Cabinet Decision number 10 of 2019, the areas would be management supervision, where the board of directors are responsible for setting the right compliance tone within the organization, and the management is responsible for managing the compliance risk arising from the day-to-day activities. The second component would be the risk assessment, where the organization must identify the crime risks, assess the exposure of the risk, and develop the risk mitigation plan based on the overall business nature and size. Policies and procedures would be another component where the organization must establish the rules of conduct and define the roles and responsibilities within the organization. The fourth component is monitoring and reporting, where the organization must focus on high risk and key regulatory requirements, keep records of control testing approach and outcomes, and provide management with prompt reporting on any non-compliances. The fifth element is the training and awareness, where the organization must create awareness among all employees on the regulation and review and access the program on a regular basis. Next slide, please. Management supervision. Now, we would like to drill down a bit more on each of these components to provide guidance on how to create the framework. Management supervision being a very critical component, as the board of directors is the highest decision-making authority for compliance risk management and ultimately responsible for setting the tone at the top, including compliance risk appetite and the effectiveness of a compliance framework. The next would be the management, who are responsible to manage the compliance risk arising from the activities within their remit and adequately providing the board of directors with information it needs to carry out its responsibilities. The third important area would be employees, who are responsible for being aware and identifying any suspicious, unusual transaction in day-to-day operations and reporting the same to the money laundering reporting officer. Next slide, thank you. Risk management. Organizations are required to identify and assess and understand the crime risk, considering the business, nature, and size while complying with the risk identification, considering the relevant risk factors such as customers, countries, geographic areas, product, services, transactions, and delivery channels. Determine the overall risk exposure and apply appropriate level of mitigation through a comprehensive compliance framework. Also, the risk assessment must be documented along with mitigation plan. The organization must keep the risk assessment up to date and on an ongoing basis. The risk assessment and mitigation plan must be made available on request by the authority. The next component would be policies and procedures, which is another key component of the framework, and it is very crucial in the framework. When designing and development of the internal policies, controls, and procedures, the same must be commensurate with the nature and size of the business. Also, key elements such as segregation of duty, delegation of authority, and customer due diligence scoring matrix must be clearly outlined. For example, customer due diligence process on customers, depending on the risk originating from the business, can be through either simplified customer due diligence, where customer or potential customers are identified as low risk, or enhanced customer due diligence, where customer or potential customers are identified as high risk. The policies and procedures must be such that are approved by the senior management to enable them to manage the identified risk and ensure compliance within the organization. The senior management must monitor the implementation of the policies and procedures and control. Also, the senior management must enhance and update the policies in accordance with the changes in the regulation. Monitoring and reporting, which is the fourth key component in monitoring and reporting, based on the assessed risk, controls, checks should be put in place for monitoring of these risks. Some of the key risk areas are sanction screening, which refers to the process of reviewing customer details in various sanction lists, such as OFAS, UN list, EU list, FATF list, etc. The objective is to identify the blacklisted high-risk individuals or entities and carry out a risk assessment on the same. The second element is the politically exposed person, PEPs. Firstly would be foreign PEPs, and secondly would be domestic PEPs. Now the organization must determine whether a customer would be customer or the beneficial owner is a PEP, and obtain senior management's approval before establishing the business relationship with the PEP, and conduct enhanced ongoing monitors on regular intervals for all the PEPs that have been identified in the system. Suspicious transactions identified wherein entities must put a control in place to detect the suspicion on occurrence of crime for suspicion transaction reporting, and regularly monitor and enhance these controls based on regulation and financial intelligence units instructions on periodic basis. During the monitoring, there will be cases that would require escalation and reporting to the authorities. These entities must implement a process wherein an employee should escalate his or her suspicion to the money laundering reporting officer. The money laundering reporting officer should make further investigation and coordinate with the board. The money laundering reporting officer and the board must come up with a decision whether it should be reported to the supervisory authority or financial intelligence unit in accordance with the reporting mechanism as laid down for the same. The last component would be the training and awareness, and which is very important. It is imperative that all employees understand the AML policy and are trained to identify and report suspicious activity. The MLRO or a third party must provide annual AML training to all the relevant employees. The training program must be tailored, understanding the trainees' daily activities and the objective and content of the AML training program will be the responsibility of the MLRO and as per the nature and activities of the person attending the training. The periodic training of all employees must cover the AML policy, the KYC procedures, UAE and global regulations, particularly the identification and reporting of suspicious transactions to the authorities. Post the training, the testing of understanding of the trainees is key. The dates when the training was given and the assessment details must be kept on records, and training certificates must be issued to the attendees. Training material must be updated, taking into consideration the regulatory developments and changes. Regular revisions of the compliance requirements shall be documented and communicated to all the employees. So these are the 5 key elements of the framework. Now, I would like to talk about the roles and responsibilities of the MLRO. Next slide, please. Where does the compliance function fit in an organization? Now, the compliance function is responsible for the compliance within the AML regulation. However, it is just not the responsibility of the compliance function, but all the 3 lines of defenses. That is the first line of defense, which is the function that owns and manages the risk. The second line of defense, which is independent function that oversees the risk and sets the standards. And the third line of defense that provides independent assurance. Hence, the organization as a whole is responsible for the AML compliance. The next, I would like to talk about the roles and responsibilities of the MLRO. The first one being detection transactions relating to any crime within the organization. Once that has been detected, review and scrutinize and study the records, receive data concerning suspicious transaction, and take decisions to either notify the financial intelligence unit or maintain the transactions with reasons for maintaining while maintaining complete confidentiality, which is a key. It is very important that the MLRO maintains ultimate confidentiality and does not inform the person on whom the test is being done. Review of internal rules and procedures relating to combating the crime and the consistency with the decree law and present decision. Assess the extent to which the institution is committed to the application of these rules and procedures. Propose what is needed to update and develop these rules and procedures. Prepare, execute, and document an ongoing training development programs and plans for the institution employees. The last would be collaborate with the supervisory authorities and the financial intelligence unit to provide them with all requested data and allow their authorized employees to view the necessary records and documents that will allow them to perform their duties. This is a very frequent question that we receive from a lot of customers. What about the penalties that have been already imposed? Now, the Federal Decree Law number 20 of 2018 and the Cabinet Decision number 10 of 2019 for AML has issued the list of penalties associated with non-compliance for entities and individuals. We have drawn down a couple of them. The penalties for an organization for non-compliance are warning to the organization, administrative penalties of 50,000 to 5 million for each violation, arresting managers, board members, supervisory and executive management members if in case of any non-compliance, and cancellation of licenses in case of any non-compliance. So this is the penalty for organizations. Now, penalties applicable for individuals. Imprisonment up to 10 years or penalty of 100,000 or 5 million or both. Penalty of 500,000 to 50 million to any legal person whose representatives or managers or agents commit any action on this account. Imprisonment of penalty of 100,000 to 1 million or both to anyone who violates the purpose. Now, the penalty of terrorism financing, which is very crucial, it is life imprisonment or temporary imprisonment for no less than 10 years shall be imposed on any person that commits this non-compliance. So this is the areas that I would want to discuss. I would like to hand over to Lydia to take it forward. Thank you.
Thank you so much, Isha, for these interesting insights. Before we hop into the question answers, I would like to welcome back Sakina. She will present some of the interesting case studies on AML. Sakina, back to you.
Thank you so much, Isha, and thank you, Lydia. So let's discuss some of the interesting case studies pertaining to the AML and CFT regulation. Next, please. So under this, you can see first case study we have covered regarding the dealers of the gold and precious metals. So the facts of the case is as such that a wholesaler of a precious metal was known to the police to engage in some money laundering activities. The wholesaler had held various bank accounts in country A, which was showed that he mostly paid to the suppliers of the precious metals in cash. Over the period of 1 year, a total amounting to euro 800 million was withdrawn in cash. So there was associated red flags that the wholesaler accounts was mainly receiving payments from the bank for purchase of bullion gold. Wholesalers' customers were mostly the shops selling gold to private individuals and intermediaries, and intermediaries that were recorded as private individuals. The wholesaler did not ask the customers for any identification. So here comes a very important aspect of the KYC compliance, that every business is required to do a KYC check before entering into any transaction. So in the detection, the supplier of the wholesaler were known to the police, leading the suspicion that the wholesaler was acting as a platform to laundry and cash payments. Upon inquiry by the law enforcement officials, it was established that much of this gold was said to have come from the black market as well as from the criminal organization that was linked to the drug smuggling and prostitution. Next, please. So the case study regarding the real estate sector, that how the criminal organizations and the drug smugglers are using the real estate as a money laundering vehicle. So under this, when we go into the facts, a member of an organized crime group created a laundering system by using other people to exchange the money for them, using the family members to purchase the various properties under their name, and then setting up the businesses in order to invest and conceal the true source of the money, which they acquired through drug trafficking. The money was transported by persons employed in legitimate transport companies who were hired by the members to hide the vehicles, to hide the money in the vehicles and cross the borders without reporting the money to the custom authorities. Subsequently, the transporters exchanged the money using the bank and exchange offices and hand it over to the crime lord. In one of the instances, the crime lord applied for a loan with a bank in country B in order to buy the real estate, which loan was later being repaid with the money he obtained through the drug trafficking. The bank filed a suspicion transaction report upon which the authorities learned of his involvement in a large scale during organized drugs crime smuggling. Upon investigation in the real estate transactions, it was being found that the property was being paid off in cash, in euros. This led the authorities to confiscate the assets as well as to stop the money laundering system. Next, please. Under this, we have covered the case study pertaining to the independent accountants and lawyers. So by background of the facts, a solicitor assisted in purchase of a number of properties for a client using the proceeds of the crime. This client was owning a luxury car business, but it was involved in drug trafficking business. There was associated red flags in the funds for purchase of the for property purchases that were generally provided in the cash from the client or from the third parties. Almost $833,000 was being provided by the client, which was a significant level of private funding despite the client's apparent legitimate business activities. So this fund was not being up to the mark of the business that the client was being into. Then in the detection of the fraud, the solicitor was convicted for money laundering, and there was a reason that he failed to make a suspicious transaction report, and he was jailed for 4 years and struck off by the solicitor's disciplinary tribunal. The court criticized the solicitor for accepting explanations about the sources of the funds at face value and not looking behind the claimed cultural customs about the funding arrangements. Next, please. Now, this case study we have covered about the trust and company service providers. So under this, the government in country Y had followed a competitive bidding process to ensure that a fair price in the construction of an airport been achieved. However, the project manager they hired to oversee the construction corruptly arranged for certain companies to rig the bidding in exchange for bribes. The contractor who operated a construction company submitted a bid for work in the construction of the airport. A government assessor believed the bid was too high, and then he arranged for a second bid to be conducted. Based on this, the targets of the investigation utilized a shell company to submit a second bid, which was way higher than the first bid. Now, as a result of much higher second bid, the contract was being awarded to the targets of the investigation on the basis of their original bid. In this complete process, the winning bid was twice the cost of the original estimates, and the government overpaid approximately $25 million for 2 subcontracts alone. Once the corrupt contractor were being paid by the government, the laundered proceeds by luring them through a series of the shell companies in several countries and paid off officials in the government as well as the corrupt project manager. So this is how the solicitor was being involved in this complete money laundering activity. Next, please. So on this slide, we have highlighted the what is way forward for all the businesses in the UAE. So we have made 3 phases into which the companies can make the compliance with the AML regulation. So first is about the assessment of the businesses which are being impacted under the AML regulation currently. Then the registration is required, and also there's an appointment of AML safety officer, which is also the MLRO. So registration are being done on goAML portal, as we have already noted in the previous slide. Coming to the second phase is the development of the AML framework followed with the training, which has been highlighted by my colleague Isha. So it is important to develop a complete framework to form the policies within the organization, to implement it, and also to arrange a proper training for all the employees, management, MLROs in the company. Then moving to the third phase, there is an ongoing compliance monitoring requirement to be done within the company to identify the suspicious transactions in the company and to timely report to the authorities. So this is a mandate from the authorities as well as under the AML regulation. Now on this note, I would like to hand over back to Isha, to Lydia, to take the session further.
Thank you very much, Sakina. That brings us also to the end of the session. We have received a lot of questions. I hope some of the questions have been already answered during the course of the session. So in the interest of time, we'll take around 3 to 4 questions live. And after the session, we will address all of them individually. So Isha, I would start with you. I got a question in addressing how long is the documents records to be kept as per the AML law? I think this question we received very often.
So the records and documents are to be kept for a minimum of 5 years.
Okay. Sakina, I will address the next question to you. We are a company with a developer license in the UAE. The project was completed in 2007. All the units have been sold and it's managing by the Owners Association. As we are the developer of the project, we have left out with 3 units unsold and we don't have any other sale or anything. We are in the winding up stage of the companies. Do we still need to register for AML? Please advise. We are neither an agent nor a broker.
See, when we see apparently the regulation, the mandate has been put on the real estate brokers and agents to do the registration, but we need to see the main objective of the regulation. The objective is to curb the money laundering activities through real estate investments. So when there are the transactions being taken place into the companies regarding buying, selling and leasing, they are required to register with the authorities. But in the liquidation, the liquidators will decide, and most likely the company is currently not required, but still if this the liquidation is being discontinued or somehow the company resume back to the operations, regardless of liquidation, then they are required to register, because they'll be in future carrying out the transactions relating to the real estate buying, selling or leasing.
Okay, thank you. Isha, I have another question for you.
Yes.
When does the organization has to undertake the CDD measures?
So an organization has to take the CDD measures ongoing, right from establishing a new business relationship, carrying out any occasional transactions in favor of a customer which is equal or exceeding 55,000 dirhams, or it could be in a single, or there could be several multiple transactions that are clubbed together that are very evident that it's a single transaction. In that case, also the company has to take care the CDD measures, and carrying out occasional transaction in the form of wire transfer. The amount that the regulation has stipulated for that is 3,500 dirhams. Any case where the MLRO feels that this could be a suspicious transaction, that also a CDD measure needs to be undertaken. And when there are any doubts, or of a customer, of previously they had doubts that the customer is always notorious and is involved in such transaction, also for those customers, CDD measures are mandatory. So overall, it is an ongoing measure, and all companies need to do it continuously. So it's not something that is once done and dusted. It has to be done on a very regular and frequent basis for companies.
Sure. Okay, thank you.
Yes.
Yeah, anything to add, Isha?
Yes, so it is a framework that is very important, and a proper policy and procedure that needs to be identified for companies so that this is done on a very regular basis. Thank you.
Sure, thank you. Now, I think we'll take one question more, and this question has been asked very often in all kinds of shapes. Does the company has to appoint an internal MLRO, or can it be outsourced? For example, if you're a small jewelry or a small firm, can an MLRO be outsourced? Sakina, would you like to take this one?
Yes, sure. So basically, MLRO is required to be appointed by the organization within the organization, but they can outsource the MLRO function to the professional experts, and they can, take an assistance to comply with the regulation. Thank you.
Thank you. I see more than 70, 100 questions still coming in. I think in the interest of time, it is 11:45. We will close the session now, but please be assured that we will come back to you all individually, or if you have any questions, please also raise them to uae@mbgcorp.com or to the, Sakina or Isha directly. So I would like to thank, of course, the speakers for sharing these insights today, as well as all the participants who have taken out time of the schedule to log in today. Please also make note of our next upcoming webinar, which will be on digital transformation, where our experts will speak on robotic process automation, a very interesting and relevant topic, on Thursday, 25th of March. Thank you everyone, and wishing everyone a wonderful day and weekend ahead. Take care.
Thank you, everyone.